Hello, gentlemen and gentlewomen. Welcome again to this channel, Legal Opinions with Clementina. I remain your favorite lawyer, Clementina E. Ukiri Esquire. In today's episode, we'll be talking about issues that concerns a vendor and a purchaser of a landed property. Now, who is the vendor in a land transaction? It's simply the person who has the land or the authority to sell a land. A purchaser, on the other hand, is the buyer. Somebody who is willing to give valuable consideration, money or any other consideration for the acquisition of the title over a land. The issues that relate to the relationship between a vendor and a purchaser and their respective lawyers is very important. Sometimes parties to a landed transaction may decide we want to use a single lawyer, one solicitor, to represent the vendor and the purchaser. For instance, party A is the vendor. They want to sell a property in Ikoyi to party B. And then they have come to me, Clementina, to act in respect to this transaction on behalf of the both parties. Some people may wonder, is that possible? Does that not cause some friction in the future? What if there is a problem in the future? Who will the transaction lawyer stand for? Who would he or she represent in the circumstance? Well, let's go into it. The question would be, can a solicitor represent both a vendor and a purchaser in a land transaction? In the case of Smith and Mansi, the court said, yes, this is a possibility. So far as some condition precedent has been satisfied or met by parties, then yes. What therefore are the condition precedents to enable a single lawyer or one lawyer to act for both parties in a land transaction? Number one is that there is no conflict of interest in regards to the interest of the lawyer and the interest of both parties. He has no interest other than to pull the transaction through, earn his fees, and go away. The lawyer and the parties must satisfy themselves of this ingredient. 2, that the title to the property is undisputed. In other words, the title is sound and there is no need for investigation of title. Because if you're acting for both parties and then you do not believe, the purchaser doesn't believe that the title is sound and is good enough, and you still have to go and do inspection, ask questions about, go to the land registry, go to the court registry to find out if there is a litigation, go to CAC to find out, the Corporate Affairs Commission, to find out if the property has been mortgaged, in the interest of a company or a corporate body. If there is need to investigate the title, it means that there will be conflict of interest, or there is a likelihood of a conflict of interest. So how do you represent both parties conscientiously in such a circumstance? So yes, the title must be sound, that it wouldn't require a further investigation of the title. Third ingredient, number 3, the parties' consent. The vendor and the purchaser must consent that this sole lawyer, this one lawyer, should represent their interest in the transaction. 4, the major terms and conditions of the contract must be certain and clear. Straightforward. There is no cumbersome terms or some unenvisaged intentions. In the terms and condition is very clear. This is your root of title. This is my money. This is the land. No, you want to use the land to farm for agricultural purpose or something, use it, blah blah blah. Terms and conditions are certain. They are not ambiguous. 5. Sometimes where the consideration is little, it is however not applicable at all times. When the consideration for the land is little, then it could be a good indication that a single lawyer or one lawyer can act for both parties. I mean, what is the interest? Is it so big that for little money, I know you get the gist. Yes. So these are the condition precedents that should be satisfied, as was made very clear in the case of Smith and Mansi, for one lawyer to present parties in a land transaction. So next time, if you know that you are able to satisfy all these conditions as a party to a land transaction, and yes, you want to factor into the transaction the fees that the lawyer is going to charge you, let me just use one lawyer so that the both parties can contribute a half of the required fees to the lawyer, and then the transaction will go very smoothly. And then it's very tidy when a lawyer prepares documentation, because they oversee everything, they ensure fairness, they ensure that every interest is protected, and the transaction is essentially seamless and straightforward. So if you know as a party that you can satisfy these 5 condition precedents, then you should consider using a sole lawyer for your transaction. But then, if there are any other reasons why you think you need a separate lawyer, please go along with your intuition and the acceptable standard. Thank you for listening and staying put, but bye for now.